things on themselves. Now, the importance of Jaylene Ward, the government finally could not find whatever they said they could find because it just wasn't there. Then they fell back to, well, she hadn't been subpoenaed. Then she said, well, I have, he just subpoenaed me. Because I had ran down and got a subpoena and gave it to her. On my own, because I couldn't have an assistant. So I subpoenaed her. So she got on the stand and she established, first witness established that she stated that there was no evidence or witness testimony to establish that the purpose and the intent of the travel was to have sex with minors. Well, technically, that ends the case. That should end the case per the judge. They shouldn't even get to the jury.
That's right. That's right.
Legally, the judge at that point should have taken action and said,
that's it.
Well, that's it.
No jurisdiction.
No jurisdiction. However, that wasn't done. All right, now, that's really the purpose of that, saying that there's no evidence of that. Because I said, my argument is, yeah, you established, arguably, a state case. You know, that there was sex, da-da-da. However, there's no evidence of a federal case at all. So that was my argument there. And I think that was considered moot.
All right, now, in connection with the travel for the purpose of having sex with a minor, do you have a witness who says that the purpose in the travel was to have the children have sex?
The witnesses that says that?
Yes.
No.
You have no witnesses that says that?
Not that says that. No.
All right. That's all I'm going to have for this witness at this time, Your Honor.
Right. And also, too, let me add, too, that it is a well-settled maxim in law that jurisdiction cannot be assumed. Once challenged, it is the duty of the district court, of the court, to show whether they had jurisdiction or they didn't have jurisdiction. When that FBI agent testified that there was no witness that can testify that Dr. York transported children over the interstate for unlawful sexual activity. All right. Once that was established, then the judge at that point should have held a hearing on that matter. Okay, and had the government prefer what they have or didn't have in reference to that jurisdiction, and if you couldn't cure it, then that judge, all right, at that point should have dismissed that case
and left it to the state.
All right, and let the state go ahead and just try their case. They're waiting to win.
My name is Dr. Frederick Bright. I'm a physician licensed to practice medicine in the state of Georgia. I have followed the Malachi Z York case from the onset during the arrest in May of 2002. I was contacted by the family as a medical expert in order to review the medical information in the accusations that was provided to the defense by the government. My review of this information was complete, and in December of 2002 I arrived at my medical opinion based on the information that was provided at that time. The medical information at that time was complete and never was updated beyond what was received in December of 2002. In my opinion letter during that time, I stated that the consistent inconsistencies in the medical history from the alleged victims led me to the conclusion that there was a problem with those histories. In other words, the histories were not medically what was expected for the type of complaints or allegations that the victims were stating had occurred. Additionally, there was a complete absence of any DNA forensic evidence, or there was a complete absence of pregnancies of any of these alleged female victims who were of childbearing age, despite the astronomical number of allegations of sexual molestation and assault that were apparently stated to have taken place. I subsequently served as the defense expert witness during the federal trial in January of 2004. During that trial, I provided testimony about my findings during my review through the month of December of 2002. Again, please note that the information that I expressed in my medical opinion in 2002 was offered to the court, and it was not used or not favorable in obtaining bond for the defendant at that time. Additionally, when a medical examiner evaluates an alleged victim, it's imperative that one obtains an accurate history of the contact that allegedly occurred. When that is absent, an examiner cannot do a thorough examination, for they do not know which body surfaces were involved in the allegations. Again, in this case, because of the significant gap between when the actual allegations took place and the time of examination, the medical examiners did not have any real ability to evaluate the body orifices that were involved in the acute stage of the alleged event. Okay, so this again puts a considerable opening for the prosecution to simply say, well, it happened just the way we're saying it, and they don't have to be held accountable for any real specifics that are normal for a sexual molestation case.
During the trip, Jacob would buy me liquor, and I was 17 at the time. Jacob would buy me liquor, and he would get me drunk, and he would fondle me, and just really harass me. And I would tell him, no, I don't want to. First off, I'm intoxicated, so I'm just like, I don't know what's going on. And secondly, I just didn't want to, and he insisted, but he eventually got the idea, and he stopped.
Jacob York asked me if I could, he had handed me 6 pages of bank statements. He asked me if I could add or forge these bank statements by adding higher deposits on the paper or the bank statements to have the sum higher than what the original sum was, meaning that add more deposits to his bank transactions that was going on over the last 2 years in order for his bank statements to appear as though he had higher or more amount of money in the sum, so he can get a loan from the bank to buy another house. And the reasons for buying this other house was because the girls that he said were moving with him were a lot of females that were moving off the land, and he named them Abigail, Atia, Ada, Esther, other females that the conversation went into the South Beach trip that he was involved with sexually. And Jacob York he confided in me certain his sexual escapades. I guess male to male, it was an ego thing for him to brag about all his sexual endeavors and who he had sex with, who was doing this, who had the best body, who could perform sexually in different areas.